Did you think getting a big settlement in an accident case was going to be easy? I did, and I handled over 400 injury cases and eventually won millions of dollars in settlements. But my gosh, was it such a grind. And I really wish I could have done things smarter to speed up results. So to make it 10 times easier for you to get a big settlement, here are 34 brutal truths about accident claims I wish I'd known earlier. Lesson 1. Let's look at a few first offers in different injury cases that I received, and then we'll look at the settlement. In case number 1, the insurance company denied liability. The settlement was $300,000. Case number 2, we had an opening offer of $12,500, and the settlement was $250,000. Case number 3, the first offer was $20,000, and we ultimately settled for $240,000. You likely noticed that the settlement was much bigger than the insurance company's first offer. Yet, in each of those cases, the insurance company told me that their offer was fair, or that my client didn't have a case. So even if the first offer they make to you seems high or even reasonable, it rarely reflects the fair value of your claim. Does this mean that you're always going to get a settlement that is 20 times the first offer? No. But it does mean that insurance companies often make a low first offer. They use a technique called anchoring. Their first offer is the anchor, and they want you to think that it's within the range of what's fair. But often it's not. Lesson 2, nothing gets an insurance company's attention more than a severe or permanent injury. I'm talking about a brain injury, a broken bone, a major surgery, or a large scar, or many other serious injuries. The more severe or permanent the injury, the higher the potential settlement. Juries usually award much more money for pain and suffering for severe or permanent injuries. Insurance companies know this, so they assign more money to the pain and suffering part of your case. On the other hand, in some car or truck accident cases, you may not be entitled to money for pain and suffering if your injury isn't permanent. Lesson number 3, I settled one case for someone who broke their leg for $65,000, and I settled another broken leg case for $445,000. In both cases, another driver was at fault and had insurance to pay. So why such a difference in the settlement amount? Well, in the $445,000 settlement, my client had surgery. In the $65,000 settlement, my client didn't have surgery. Cases involving surgery often settle for more because of the pain, recovery, and costs involved. And not every surgery is equal. In terms of assigning a pain and suffering value to your case, some surgeries are worth much more than others. For example, a back fusion surgery is going to be worth much more than a smaller surgery like surgery on your pinky. Lesson 4 is that some insurance companies are much cheaper than others. The bad news is that the most common auto insurers are often the worst. Take everything you know from their funny ads and throw it out the window. 2 of the companies who have the best ads are really cheap in personal injury claims. I'm talking about Progressive and Allstate. One step better, but still tough, is State Farm. One grade better than State Farm are Geico and USAA. But even Geico and USAA play hardball. Lesson 5 is who you choose as your lawyer matters. Experienced attorneys know how to maximize settlements through negotiation and evidence. After handling personal injury cases for 21 years, my skills are much better than when I only had 10 or even 15 years experience. Through my long journey, I learned game-changing tactics that have helped me get many large payouts. And if you've been injured in an accident in Florida and you think that someone else may be at fault, click the link in the description below to see if I can fight for your large settlement. Lesson 6 is that ongoing or chronic pain from an accident is worth more than pain that goes away. For example, someone who gets treatment for 2 years of back pain has a better case, all things equal, than someone who goes to only 2 medical visits complaining of back pain. The reason is because medical records showing long-term pain increases compensation for pain and suffering. Lesson 7 is if your attorney is willing to take your case to trial, insurance may offer more to avoid court. The case becomes more real to the defendant as trial approaches. Because if the insurance company settles, they control the amount. Whereas at trial, it's the jury who gets to write the check, as they say. Lesson 8 is cases where the other party's fault is undeniable tend to settle for more. If the police report supports your case, it helps. But please do your independent investigation. Some courts don't allow the jury to see the police report. Insurance companies know this. Lesson 9 is that use of strong medications like opioids or muscle relaxers can indicate severe pain. But of course, only use what's prescribed. If you're taking opioids, it's worth more than if you're just taking over-the-counter meds like Tylenol or Advil. And if the paramedics or ER gave you a heavy drug like morphine, you should point this out to the insurance company for the at-fault person or business. Lesson 10 is that if the other side was reckless and caused your injury, the case can be worth more. For example, if the at-fault driver got a DUI, a jury may be bothered with them and want to punish them. They can do this by giving you more money for your pain and suffering. Or maybe the jury will award punitive damages to punish the other driver. Insurance companies know this, and their offers may reflect this. Lesson 11 is having high past medical bills gets an insurance company's attention fast. This is because they owe you for your medical bills if their insured caused your accident. The same is true if your future medical expenses are big. The insurance company owes you for them if their insured caused your injury. I see people not go to the doctor because they're scared of racking up big medical bills. But if you're injured and you need treatment, please go to the doctor. You should be fine as long as someone else caused your accident and there's insurance to pay. Substantial past and future medical expenses show that your injury is serious. Lesson number 12 is injuries like scars, burns, or other visible damage often result in higher settlements. Consider letting the insurance company see your scars, burns, or other visible damage. And please take high-quality photos of these. Modern cell phones do a great job. I often have clients who send me photos of their burns or scars from an accident, but they don't tell their doctors about it because they think the scars are small, and doctors are often in a rush trying to get to other patients. Always tell your doctor so they mention your cuts or scars in the records. Otherwise, you may face a huge fight with getting the insurance company to pay you for your scars or burns. Lesson 13 is that not all medical treatment is equal. Treatment by specialists like orthopedists and neurologists may boost your settlement value. They're much more persuasive than chiropractors. The same is true if you claim that you had a concussion or minor traumatic brain injury. If a neurologist is treating you, that's better for your case than if you're complaining of a head injury to a chiropractor. This is because neurologists specialize in head injuries, chiropractors don't. Lesson 14 is showing lost income and future earning potential can raise your settlement, but you'll need a doctor's note to say that you were excused from work. It also helps for your employer to complete a form showing your average weekly pay in the 3 months before your accident. You then send this form to the other side's insurance company. Lesson 15 is strong records of diagnosis, treatment, and future medical needs are crucial. Don't expect a big payout without medical records. Even if you have a serious injury like a herniated disc or a tear of a muscle, ligament, or tendon, you want your medical records to say that the accident caused it. If they don't, ask your doctor to write a letter stating this. Lesson 16 is that less fault on your side increases your payout. Your case value gets cut by your percentage of fault. For example, if you're 20% at fault, the other side only owes you 80% of the full value of your claim. And if you're 40% at fault, the other side just owes you 60% of your full claim's value. So if you're 20% at fault, your case is worth 2 times the amount than if you were 40% at fault. And in most states, if you're over 50% at fault, the other side doesn't owe you any money. Lesson 17 is to be careful if the insurance adjuster asks you what range to settle for. Let's say that you're willing to settle your case for $100,000 and they ask you what range you'd accept. Please don't say $100,000 to $150,000. This is because when you tell them the low end of your range, they're going to write this down. And $100,000 has become your new ceiling in the case. In other words, it's the most that they're going to offer you. But the reality is that the insurance company will likely try to get you to accept much less. Insurance claims adjusters are the best negotiators I've ever dealt with. Lesson 18 is to know the at-fault party's insurance policy limits, as it may help you make a larger demand. For example, if the at-fault party has a $100,000 insurance policy, I'm more likely to demand $100,000 than if they only had $50,000 of insurance. This is because it's often 10 times easier to get an insurance company to pay than someone without insurance. That said, your case still needs to have value. I won't demand $100,000 on a case that's worth only $5,000 or so, because I'm just delaying the settlement and wasting time if I demand 20 times what the case is worth. Lesson 19 is that taking legal action may pressure insurers to settle for a higher amount. In other words, you may need to sue in some cases. This is especially true if the insurance company denies liability. I've settled many cases during a lawsuit that should have been settled before a lawsuit, but the insurance companies were stubborn. They thought I'd go away, but I didn't. Sometimes suing gets the insurance company to assign your case to higher level adjusters. They're more experienced and can recognize when they should be paying out. Lesson 20 is witnesses who support your version of events can add weight to your claim. A witness who supports your case can be the difference between winning and losing your case. For example, Richard was riding a motorcycle when he claimed that a driver cut him off and intentionally slammed on the brakes. Here, Richard crashed into the back of the car. You've probably heard that in rear-end accident crashes, the car that's behind is at fault. Yes, that's usually true, but not when the car in front intentionally slams on the brakes. In Richard's case, a witness said that the other driver was at fault. As a result, we were able to settle Richard's head injury case for $60,000. Get the witness's statement recorded as soon as possible after your accident. As time passes, they're less likely to help you because they're less emotional about what they saw. I've had witnesses who were sweet at the accident scene, and shortly later they stopped taking my calls. Lesson number 21 is experts like doctors, accident reconstructionists, or economists can validate your case. If your doctor won't support your case, you may have some big problems. This is because it's your burden to prove your case. The other side gets to hire their own doctor to examine you. Their doctor, unfortunately, is likely going to say that you're not badly injured. Often, their doctor will say that the accident didn't even cause your injury. I know it's horrible. This is especially true if you're claiming one of the following injuries: a minor traumatic brain injury, a herniated disc in your back or neck, a tear of a ligament, muscle, or tendon. Experts can charge big money, so if you don't know which to use or can't afford them, I suggest calling a lawyer immediately. Lesson 22 is pictures or videos of injuries, damaged property, or the accident scene make claims more compelling. It's why you're watching this video instead of reading an article. A picture or video speaks 1,000 words. I usually include photos of my clients' injuries in the first letter that I send to the other side's insurance company. I want the insurance company to see the injury. And if your accident involved a big impact, send them photos of the damaged vehicles. Lesson 23 is that video or audio showing the aftermath of the incident can sway settlement amounts. Think about how many movies you've watched that show the aftermath of a bad accident. They show this to keep your attention. Well, it also keeps a jury's and adjuster's attention. And get this video or audio soon because it often disappears fast. Police departments are taking a very long time to send out body cam footage lately, so request it immediately after the accident. Lesson 24 is that your credibility and consistency in recounting the accident affect the insurer's perception of you. And I beg you to please don't give the other side's insurer your recorded statement, as they'll poke holes in it later. Lesson 25 is that evidence of mental anguish, PTSD, or loss of enjoyment in life can increase payouts. If you're fearful, depressed, or worried, tell your doctor so they add it to your records. Don't be ashamed to see a mental health counselor. Don't waste your time telling the insurance company that you now have mental health issues if you haven't seen a doctor yet for them. Lesson 26 is that people who are relatable may receive higher settlements. Jurors tend to award more money to nice and honest people, and insurance companies know this. Lesson 27 is to show the insurance company how the accident has affected you. For example, if you can't hold your child due to the injury, send the insurance company a video of you holding your child before the accident. If you love to play the guitar or piano, but you have a broken hand, arm, or shoulder, send the insurance company a video of you playing the guitar before the accident. Lesson 28 is to let the insurance adjuster talk when they are speaking with you. It's our natural tendency to want to explain things to them or to get mad if they make a low offer. However, don't interrupt them because they may be about to tell you information that can increase the value of your case. Let them finish talking and get comfortable with there being 5 or even 10 seconds of silence after they finish speaking. They may speak more and give you more valuable info. I've had this happen many times, and my clients have gotten sizably more compensation because of it. Lesson 29 is to give the insurance company time to respond to your offers and counteroffers. Adjusters often have over 150 claims at one time, and yours is just one of them. Lesson 30 is if the insurance company is not responding to you, consider drafting a consumer complaint to the state's Department of Insurance. But if you're going to do this, send the adjuster a draft of it before filing it. Give them this courtesy and you may stay on their good side. Copy their supervisor on the email. I've seen adjusters go silent for weeks, sometimes even months, but then come back with a big offer right after I email them a draft of a consumer complaint. Lesson 31 is if the claims rep makes you a settlement offer over the phone, ask them to put it in writing. I used to get nervous to ask them as I somehow thought it would make me seem weak, but that was just my fear talking. There are 2 reasons to get their offer in writing. First, you won't forget it. Second, you'll have it in writing in case the insurance company changes adjusters in your case. Lesson 32 is that the adjuster is writing down everything you say. Their notes are permanent. If they tell you something is off the record, it is not. Please don't fall for that trap and let it destroy your case. Lesson 33 is that you will likely need to pay your health insurance company from your injury settlement. I call this the second part of your personal injury case. But don't automatically assume you owe them what they demand. You may only owe them a small fraction of what they're demanding. This is true no matter how strong their demand letter to you seems. After you settle your personal injury case, you should be fighting to pay your health insurer less than what they're asking you for. I've even gotten health insurance companies to give up their demand to get repaid. If you have a lawyer, your health insurance company may be required to lower their demand by your share of lawyer fees and costs. Lesson 34 is don't stop learning about accident claims. Otherwise, the insurance company is more likely to take advantage of you. But you also need to understand how certain people in accidents got a large payout. And I exposed just that in the video that's on screen now. Link in the description below, so watch it now. And if you've been injured in an accident in Florida, click the link in the description below to see if I can fight for your large settlement.